This is so exciting because I have been following this case from the very, very start. Oh my God, how many years ago was that? 6, 7? 6, 7. Oh no, 2015, 11 years. Wow. Oh my God, and we got a wonderful Supreme Court ruling in it. So fantastic to see all of this resolved and resolved correctly. We'll get into that, but first let me kind of review, for those of you who haven't been following it with me, just what Cox v. Sony is all about. And this is about those DMCA notices you get whenever they think you've pirated something. And they say if you get so many of these notices, you'll be shut off. Cox was not exactly refusing to go along with it. They were doing it. They just weren't really doing what the content cartels wanted them to do, which is shut off everyone who is pirating. Now understand, those notices only happen because some half-assed bot run by a record label says they're pirating. It's just an assertion backed up by nothing. And unbelievably, a Virginia jury found that Cox should have to pay $1 billion to 53 record labels because they wouldn't shut off the internet access of users based solely on the say-so of one of the labels. There's not a warrant. This isn't a court order or anything. Just some rando going to the ISP saying, hey, we're with the record label, that person's pirating, shut them off, with no evidence and no way for the user to defend himself. An assertion backed up by nothing. And they ordered Cox to pay $1 billion because they did nothing in response to it. That's important. This is for doing nothing, for taking no active steps to kick these people off of the internet. And if you followed my coverage about this, you know that they've actually lied about the evidence in the court case. They used a company called Mark Monitor to send these copyright infringement notices, which is basically the digital equivalent of crystal balls and horoscopes. Well, during the Cox trial, they submitted a hard drive containing the songs that were supposedly pirated between 2012 and 2014, but the drive itself wasn't created until 2016. And they were later reconstructions of what the record labels said they were pirating, not the actual pirated files. I mean, this should have been thrown out faster than a primed grenade. Much of the evidence was just assertions created after the fact, but the courts just said, this is fine. Cox was also denied probative, potentially exculpatory evidence, which prevented them from fully defending themselves at trial. But U.S. District Judge Liam O'Grady said, none of that matters. Doesn't matter if the evidence was recreated. Doesn't matter if 2 of their witnesses gave false testimony about the hard drive's contents. It doesn't matter whether the files were verified before or after the fact. I mean, we're talking serious allegations of misconduct. The judge didn't even try to deny that misconduct. He accepted them as true and said, still doesn't matter. He literally said that perjury and fabricating evidence was of no consequence. And also, it was Cox's fault for not catching it earlier. Yeah, the fix was in with this judge, like there is with so many. So the judge said that Cox's internet service was indispensable to each instance of peer-to-peer infringement on its network. Well, so was the electricity going to their homes. They couldn't have done it without the power. So what's next? Get the power company to shut off the electricity to people you're saying are infringing? What's the difference? Shut off one public utility, shut off a different one? Really what this case is about is that ISPs should be unpaid enforcers for the RIAA, shutting off the internet access of entire customers based solely on their say-so. By the way, this is also the judge who greenlit the mega upload case against Kim.com. He's also the one who sentenced whistleblower Daniel Hale to the second harshest sentence for a whistleblower ever for leaking the drone papers. Remember those? Yeah, when are we ever going to start punishing judges for crap like this? Alright, so that was the lower court. It was appealed to the Fourth Circuit, who should have shut it all off right then and there. But nope, this is completely disrupting all of the doctrinal consistency around this. If they had followed the precedents of Twitter and Grokster, they would have concluded that a provider of an online service cannot be secondarily liable merely for providing that access. That has never been the case. And there's no reason to think that Congress intended a topsy-turvy regime like that, but we're talking about things that would cause innocent subscribers to lose their access. There would be no way for an ISP to avoid liability other than to just shut off the internet for them. Completely. Not just for the infringer, but for everyone who uses that connection. And that could be not just an entire home, but an entire town, a university, a hospital. There was one case where they went after a homeless shelter because someone at the homeless shelter had pirated a song, and they wanted them to shut off the internet for the entire shelter. So should an entire hospital be cut off just because one of their patients pirates a song? Yeah, go ahead, cut them off. None of the doctors can get the information they need. Oh, that telemedicine, cut it off in the middle of that brain surgery. Who cares about the patient? Someone downloaded a song. That's basically what the record company argued. That was even an example brought up in front of the Supreme Court. The law says go after the person committing the act, not the innocent bystanders. And I think the worst part, and no one else is making a big deal of this, and they should, the RIAA's ambulance chaser said this directly to the Supreme Court. I'm quoting, "There has to be room for treating somebody that says F the DMCA differently from somebody that tries their level best to comply." That is a direct attack on free speech. I don't know if the justices picked up on that, but that's basing it entirely on the content of someone's speech. Because that was the thing in the case. There was a communication or something where someone at Cox just got exasperated and said, F the DMCA. Absolute content-based censorship. But the problem is, if you find contributory liability for infrastructure, where does it end? Could it be the phone company, cloud hosting, VPN service, Discord admins, Tesla charging stations? All of that would have been fair game if this decision had gone the wrong way. Thankfully, it didn't. 9-0, unanimous. There is a bit of whinging from Sotomayor and Jackson in a concurrence that we won't go into. They just hate that the rest of them didn't leave it open to just make up more contributory infringement wherever they wanted. You actually have to follow the law. Imagine that. But that's what we have here, fresh off the presses. This might be like a couple days later by the time I get this posted, but I wanted to actually sit down and go through it so you know what actually was said and what wasn't said, because there's already a lot of misinformation going about this from both sides, as is usually the case. So we'll see what Judge Clarence Thomas says here, writing for the majority. Countless people use the internet for legal activities, but some use it illegally to share copyrighted works, such as songs and movies. In this case, however, instead of suing those infringers, the copyright owners sued petitioners, Cox Communications. They contended that Cox itself was liable for copyright infringement because it continued to provide known infringers with internet access. Based on this theory of infringement, respondents, Sony Music Entertainment, and other major copyright owners secured a $1 billion verdict against Cox. The United States Court of Appeals for the Fourth Circuit agreed that because Cox provided internet service to known infringers, it was a willful infringer itself. Under our precedents, a company is not liable as a copyright infringer for merely providing a service to the general public with knowledge that it will be used by some to infringe copyrights. Accordingly, we reverse. So as he explains, many users can share a particular IP address. For example, a household, coffee shop, or college dormitory ordinarily has one IP address, but has multiple individual users. ISPs such as Cox have limited knowledge about how their internet services are used and who uses them. They do know which IP address corresponds to which subscriber's account, but they cannot distinguish one individual user from another. For instance, if an ISP learns that someone illegally downloaded music from a coffee shop's IP address, the ISP cannot determine which individual at the coffee shop infringed the copyright. And more generally, ISPs also cannot directly control how their internet services are used. And believe me, they've tried. But the problem is, the Copyright Act does not expressly render anyone liable for infringement committed by another. Ordinarily, when Congress intends to impose secondary liability, it does so expressly. Although our precedents have recognized specific forms of secondary copyright liability that predated the Copyright Act, we are loath to expand such liability beyond those precedents. Which is what a lot of judges would want, and apparently Sotomayor and Jackson want. You just let the judges just kind of make up secondary infringement wherever they want to. It's not how this is supposed to work. And maybe before, when they were kind of left on their own to figure it out, that was one thing. After Congress passed the Copyright Act, it was explicit at that point. If there is to be any more secondary copyright infringement liability, Congress has to create it. So the only thing you can go by is those couple of precedents and what's in the Copyright Act, which is basically the provider of a service is contributorily liable for the user's infringement only if it intended that the provided service be used for infringement. The intent required for contributory liability can be shown only if the party induced the infringement or the provided service is tailored to that infringement. For example, in Grokster, we held that a jury could find two file-sharing software companies liable for inducement. The companies promoted and marketed their software as a tool to infringe copyrights. They said it outright. This is what it's for. A service is tailored to infringement if it is not capable of substantial or commercially significant non-infringing uses. In Sony, copyright owners sued the maker and the retailers of the Betamax videotape recorder. The tape recorder could be used to record copyrighted television programs for later personal viewing, which would not constitute infringement, even though they wanted it to. They lost that one. On the other hand, it could also be used to reproduce and sell copyrighted television programming, which would constitute infringement. The lower court found the Betamax maker liable because the tape recorder was not suitable for any substantial non-infringing use, and infringement was either the most conspicuous use or the major use of the Betamax product. This court reversed, concluding that the Betamax is capable of substantial non-infringing uses like personal use, so sale of such equipment to the general public does not constitute contributory infringement. Yeah, I wonder how many people realize we were that close to not being able to have VCRs. If the big movie producers had had their way, that would have been shut off. And Sony wasn't a big movie producer at the time they were making the product. And if it had gone the other way, home recording would have been shut off to us. This court has repeatedly made clear that mere knowledge that a service will be used to infringe is insufficient to establish the required intent to infringe. Because otherwise you could apply that to everyone, couldn't you? In Sony, the court explained that there is no precedent in the law of copyright for liability based only on the fact that the defendant has sold equipment with constructive knowledge of the fact that its customers may use that equipment to make unauthorized copies of copyrighted material. And in Grokster, the court confirmed that a court would be unable to find contributory infringement liability merely based on a failure to take affirmative steps to prevent infringement. Thus, Cox is not contributorily liable for the infringement of Sony's copyrights. Holding Cox liable merely for failing to terminate internet service to infringing accounts would expand secondary copyright liability beyond our precedents. And that would make them unpaid law enforcement, cutting off people's internet based on rumors. Whole households, businesses, campuses, hospitals, anyone sharing a connection without anything ever having to be shown in court. That's insane. Cox neither induced its users' infringement nor provided a service tailored to infringement. That was a big deal. They were like, oh, Cox is getting money for this. And Cox was like, we get paid the same way if people don't infringe. What is it to us then? They didn't benefit really from infringement. Sony provided no evidence of express promotion, marketing, and intent to promote infringement. Cox's internet service was clearly capable of substantial or commercially significant non-infringing uses. Cox did not tailor its service to make copyright infringement easier. Cox simply provided internet access, which is used for many purposes other than copyright infringement. And if this had gone the other way, then the safest move for any provider of anything would be either to over-police everything or just shut people down entirely rather than risk the liability. That's what would have happened if this turned out the other way. The Fourth Circuit found otherwise based only on its circuit precedent, establishing a new form of contributory liability that they just made up. It's magic. They used their imagination. It's a new form of liability. The court did not suggest that Cox induced its users to infringe, and it did not deny that Cox's service was capable of substantial lawful use and not designed to promote infringement. Rather, the court held that supplying a product with knowledge that the recipient will use it to infringe copyrights is sufficient for contributory infringement. Just knowing that someone's going to do it is enough. That someone out there, somewhere, in this big old crazy world of ours is going to infringe, that's enough. The Fourth Circuit's holding thus went beyond the two forms of liability recognized in Grokster and Sony. It also conflicted with this court's repeated admonition that contributory liability cannot rest only on a provider's knowledge of infringement and insufficient action to prevent it. Finally, Sony argues that the DMCA safe harbor would have no effect if ISPs are not liable for providing internet service to known infringers. Sony argues that Congress must have enacted the DMCA on the presumption that ISPs could be held liable in cases such as these. Sony overreads the DMCA. Sony does not contend that the DMCA expressly imposes liability for ISPs who serve known infringers. It does not. The DMCA merely creates new defenses from liability for such providers. That's another big mistake we keep seeing. There's a new defense that Congress or the Supreme Court sets up, and then they use that new defense to read in new powers that they have. Oh, you have fair use? Well, if it's not fair use, we can do whatever we want. Well, no, that's not the case. Or here, we've got a new defense from liability. Well, that means we can pound on you in every other case and you do have liability. No, it doesn't. It's not what that means. And the DMCA made it clear that failure to comply with the safe harbor rules shall not bear adversely upon a defense by the service provider that the service provider's conduct is not infringing. So there. The judgment of the Court of Appeals for the Fourth Circuit is reversed and the case is remanded for further proceedings consistent with this opinion. It is so ordered. Mic drop. Great victory for you and me. Now, what'll it actually mean? Well, this verdict is not going to stand. I don't see how they're going to be able to do anything other than just dismiss the case entirely. But what's it going to mean for other cases? What's it going to mean for Yout? What's it going to mean for our ability to have fair use of YouTube videos? Just because we're infringing by hitting the F12 key. That's basically what they're arguing. See my coverage on that. And all these AI cases where we're covering all of these attacks on free speech and fair use. Will it have a positive effect on them? Maybe it won't help, but it definitely won't hurt. So this is a good day. Things have changed. Things are no longer the way they've been for the last 20 years. The Supreme Court saw it that way unanimously. Such a relief. And thank you so very much for watching. Comments for the comment god, shares for the share throne. Please hit like, subscribe, and the bell. And of course, donate. Doppelgosity.tv keeps me doing all this. I can't believe I've been covering this for 11 years, man. Wow, thanks so much to those who have followed me through the whole thing. Yeah, so you can help with one-time donations or regular support, Patreon, Subscribestar, or Discord. Thank you so very much for watching. Until next time, stay strong and be free.